Right. Good evening, everybody, and joining ORF for this discussion on India's proposed data protection law and a US-India executive agreement under the Cloud Act. Now, what does that title mean? To set the context, cybercrimes and other offenses in cyberspace may be borderless, but the realities of borders do remain. And we see this, for example, in the fact that multinational tech giants that house vast troves of data are headquartered in and therefore answerable to particular jurisdictions. Now, currently, law enforcement agencies in India rely on mutual legal assistance treaties, or MLATs, which many describe as unwieldy and slow, which are two adjectives generally undesirable when it comes to investigating cybercrimes. The Indian government has sought to correct this issue through various measures, including data localization proposals, much displeasure of businesses that cite the need for data to roam free. What are the alternatives? That's where the Cloud Act comes in. It offers a path for foreign governments to access data stored by US service providers. Can we make the Cloud Act work for India? Will data protection legislation be enough given India's myriad of interception, decryption, and sectoral data frameworks? We are joined this evening by Srinivasan, who is a partner at Ikigai Law. She has co-authored a report using the US's negotiations with the UK as a precedent for how India could meet the requirements of the Cloud Act. We're also joined by experts who will attempt to resolve some of these intractable challenges on data, privacy, innovation, and regulation in the span of an hour. So we'll turn to you, Sreenidhi. Sreenidhi, please provide some highlights from the report. What are the key recommendations? Following which we will turn to the other panelists for their inputs as well.
Sure. Thank you. Thank you so much, Trisha, and the ORF team for having me here. Very good evening, everyone. I'll perhaps start with setting a little more context, just building on what Trisha had talked about, just setting up the context for the paper, our approach, and then the big themes, the big takeaways. So at the time of writing this paper, it sort of predated the withdrawal of the data protection bill from Parliament, which to my mind makes this conversation all the more relevant as the government now looks to finalize its approach to data governance generally and specifically themes like data localization. So the origin of this paper, like Trisha sort of pointed out, is challenges that investigative authorities in India and in several other countries in the world often face in accessing data from other foreign service providers, US service providers, especially. I think despite an investigation sort of being entirely Indian, if say, victim, perpetrator, location, incidence of the crime is entirely domestic Indian. If say emails are stored with a US service provider, the service provider is also bound by and answerable to the home country laws. And US allows these companies from sharing data for law enforcement purposes unless you follow a certain kind of legal process. US law requires what is called a probable cause warrant to share emails or other communications content. And these warrants are, of course, issued by courts in the US. So there's some judicial authorization built in there. Naturally, courts in India can't issue these. So what is required to make this sort of cross-border data sharing for law enforcement purposes work is pursuing what Trisha referred to, what's called the mutual legal assistance treaty route, which are bilateral arrangements between different countries, say India, US in this case, where a request will be routed through the Home Ministry, the MHA in India. Courts in India may also have to issue something called letters rogatory, pass it through certain channels, approach the US DOJ. Naturally, this is a cumbersome and tedious process. Peter can speak to this a little more on just how long this takes to execute a certain kind of request, anywhere from 10 months to 3 years. So for the government, localization seems then like an alternative way perhaps to be able to access data, but localization and local storage obligations around data come with their own set of issues. Critics have pointed out, questions around whether this is placing borders for data, whether it's the most technically efficient way of just processing data in any way, how local storage obligations would be unworkable or infeasible in certain kinds of, say, cloud computing or other scenarios, whether this can impose a trade blocker and so on. At the same time, I think we're all cognizant of legitimate law enforcement concerns and measures to speed up investigations as well. So against that backdrop, one potential pathway was the US Cloud Act, which was enacted around 4 years back, which provides an alternative, sort of removes them in US law and allows foreign law enforcement to directly seek access to data stored with a US service provider. When this law was enacted, a lot of the initial commentary did suggest that it might be difficult for countries like, say, India to conclude an agreement with the US. There are some checks within the Cloud Act where the US government, different administrative and sort of wings of the government will evaluate the partner countries' domestic laws around surveillance, government access, and a host of other requirements around, say, free speech, civil liberties, etc. In our paper, we focused on two key requirements, which we thought were relevant as India also finalizes its data protection law. One was just having clear mandates for government oversight and government access to data, and a commitment to free flow of information and an open internet. Our approach here was to look at past negotiations. So far, the US has concluded agreements with two countries, the UK and Australia. We looked at documents around the US UK negotiations, what were the sticky issues, bottlenecks, compromises made. And we offered four key takeaways, which we thought were relevant as India looks to finalize its law. The first related to whether you need to overhaul the laws entirely. Second was on the US approach to substantive protections. Third was on India's data protection proposal on its law, how it could bolster some of these. And fourth was on local storage. I'll spend a minute just on each of these takeaways and themes. So the first one was, I think one key theme that emerged from the UK-US negotiations was that an overhaul of the foreign country's law may not always be required when you're entering into an executive agreement or when you're negotiating an agreement under the US Cloud Act. So one sticky issue that comes up often is US law requires prior judicial oversight over government requests. So many argued that countries that don't require that for government access, like the UK and India, might not meet the mark then. But the approach in the UK was slightly different. I think instead of amending the entire schema of laws, the UK enacted one law, the Crime Overseas Production Orders Act, which to give effect to this agreement and also sort of propose the requirement of judicial oversight for only the subset of requests, where, say, UK courts could then request directly access by US service providers rather than going through the MLAT route. Similarly, free speech was a sticky issue in the US-UK negotiations, where certain UK laws were seen as problematic and not meeting US free speech protections. So the agreement that was negotiated provided for an additional layer of review. So for cases that involved free speech offences in the UK, there was an additional review before direct requests could be made for evidence. The second takeaway was just on overall approach when the US Attorney General, who's sort of evaluating the partner country's domestic laws, looks at is, our sense was that in the substantive assessment, the government may take a more lenient approach. For example, the UK law did not require prior judicial authorization for issuing interception warrants. But the the government actually still found the UK to have sufficiently clear mandates for access and oversight, a double sort of dual lock-in mechanism through different layers of review, even though those were not always courts that were sitting at the top reviewing these requests. The third big theme that we looked at was what could India's data protection law do just to bolster protections? Could we offer certain additional protection to make this case stronger, that India does offer robust protections for privacy and has clear mandates for oversight? And we thought this was not just relevant for the a potential India-US conversation, but also if India were to potentially seek adequacy from the EU or continue to make a case for data flowing in from the EU or actually anywhere else into India, building that sort of trust. So adding, say, the data protection regulator as an additional layer of oversight, the proposed data protection regulator under the law, who could also evaluate, say, law enforcement requests as an arbiter there. or requiring these, even for investigation purposes, instituting at least a basic set of privacy norms. While notice consent might not make sense at all in investigations, perhaps requiring them to abide by security safeguards or even just data minimization or having some kind of retention policies, those principles might still make sense. And having blanket exemptions might take us farther away from being able to negotiate such agreements. And the final theme was just on local data storage obligations. I think, as you would all know, our financial sector regulator RBI already has implemented local storage requirements for payments data. So a subset of payments data, payments instruction must be stored on servers in India. We're also seeing a trend in say other sectors, health, etc., where we might see local storage obligations coming in. The version of the law that was being discussed, the 2019 version, also had local storage requirements for certain kinds of data, sensitive data, which includes financial health data. And our sort of takeaway there was, if it's a mirroring requirement where you are requiring a copy of that data to be mirrored in India, while also providing some channels to be able to share data across borders under mechanisms like contracts or other measures, certifications, and so on. There may still be some room to negotiate an agreement under the cloud, because if you allow that sort of enabling framework, if it's mirroring, as opposed to a very exclusive data storage requirement in India. So those were sort of our key takeaways. I'll pause there and perhaps happy to answer any questions in the course of the session.
Thanks, Sreenidhi, for condensing your report into those crisp takeaways. We'll now turn to the discussion portion of this session. So we're joined by Astha Kapoor, who's the co-founder of Apti Institute, Arvind Gupta, who's the head and co-founder of the Digital India Foundation, Peter Swire, research director with the Cross Border Data Forum, and finally Ashish Agarwal, who's vice president of public policy at NASSCOM. Peter, I'll turn to you first. As Sreenidhi mentioned, you have written on how the MLS has often been an impediment to India-US law enforcement cooperation, and how the Cloud Act could greatly simplify that process. What is your assessment of Sreenidhi's recommendations? And does the UK case study provide an adequate precedent, given that the US and UK have a very different relationship, and intelligence sharing, for example, historically has always been a part of that?
Hello, and welcome to Sreenidhi, Srinivasan for her here. I'm background as a U.S. law enforcement official who's worked on a lot of these on mutual legal assistance, and I lead the cross-border working exactly on these issues. How do you get legitimate law? How do you also protect privacy? And the governments are seeking these data, make it workable so the companies for to apply. And how do we do internet that meets many values? And it looks like I may be frozen. Me, or is it just?
Yes, Peter, your audio is cutting off a little in the middle.
Huh. Okay, change that. I apologize for any difficulty word and where I am. In any event, key point from Srinivasan is that all of its criminal procedures, things that it did in order to meet. Instead, they created a special for the times. There's this international data order. So you could imagine for India investigation.
Peter, really sorry to interrupt, but we're hardly able to hear what you're saying. Could you perhaps change your connection?
Yeah. It was good for 45 minutes, and now I can come back.
All right. So we'll get back to Peter in a minute once he's able to change connections. But meanwhile, we can move on to some of the other speakers and get their views as well. I'll turn to you, Ashish. The Indian government's aspirations to transform India into a $1 trillion digital economy ride on the reality of interoperable data ecosystems. But at the same time, a laissez-faire approach will do more harm than good. So how do we reconcile these realities? And is there an ideal balance that can be struck?
Yeah, thanks, Trisha, and I hope you can hear me. All right, perfect. So, what you described, Trisha, is actually an interesting problem to navigate, right? So, and that's what nations are trying to do today. And before that, I think just to comment on what Sreenidhi kind of summarized, some of these solutions are actually worth pursuing, and this is going to take a bit of time also. So, therefore, we can always take nuggets of learnings from what happens when US does it with UK, or for example with a few other countries where some progress has happened, or agreements have happened. So in that sense, I guess, but if you look at it from an Indian perspective, clearly we are in a much more let's say, and this is what each nation needs to evaluate from its where its industry is, what are its priorities in terms of how can it make the best outcome possible for its own economy. And when you look at it from that perspective, clearly uh, we have to first think of it that if we are to think of a executive agreement under the Cloud Act, where does it sit in priority as of today? And not necessarily just from an Indian perspective. Look at it from a US Indian perspective. So, in my limited experience of having conversation on this topic, clearly I don't see this right now as a top of mind agenda. So one, you could definitely then think about it that it is in the natural sequence of things that this shall at some point in time get to that stage where it will become a priority. So that's, I think, one part of the conversation that we need to see it as something which will potentially be useful. The other aspect is that from a government of India perspective, all the big tech are operating in India. They are subjected to Indian jurisdiction, and we have the IT Act and we have the interception rules. So when government of India wants to access information, I would think that the first area where government of India would want to focus is to try and make sure that it can get what it wants through its own domestic laws, and then possibly reach a stage where there is a significant enough motivation to say that an alternative which can be much better must be explored. So have we reached that stage where we see this? And that's why I think from an industry perspective, it is a bit of a challenge. So I think Peter mentioned about MLATs briefly to the extent I could hear him. But I'm assuming that the very idea of MLATs predates the concept that A country could be asking data from B country about operators who may not be in either of these countries, and be using data of a country. So I think that entire construct that the data is sitting somewhere, and the industry elements are subject to multiple jurisdiction, and then data is being sought of the home country, if I were to call A the home country in that sense. I think that entire construct wasn't probably the objective or the problem that MLATs were initially even trying to solve. So that itself is an instrument which is outdated from such a perspective. Now coming back to India, I think so we're going to see this journey, and in this journey, industry is faced with uncertainty. So you have to comply with the Indian law to be answerable to the request in India, and at the same time try to reconcile with the position in the US domestic laws. And of course, the Cloud Act tries to offer a solution, but it is still to be seen. Are nations willing to bite the solution, or they're going to probably react in a similar fashion to US, so that you are subjected to my jurisdiction wherever the data is. You give me that data, and when we get into this position of potential conflict, that there is a kind of a conflict with the law of the other country, we will try and sort it out mutually. And I think that process of sorting this out mutually has to be played out enough for it to actually result into people going back into the drawing room and saying that, this kind of thing will work. So that's, I think, one part of the debate and discussion that we need to really see. The more positive takeaway of all this, when you look at when under the Cloud Act, what is the expectation of the US government? Under GDPR, what is the expectation in terms of adequacy, and so on and so forth. So I think there is a clearly, now sitting in 2022, there is a common understanding that there are few things which are key to make cross-border data flow happen, and these are the elements which will make data protection interoperable across countries. Now, even within this, I think Sreenidhi alluded to it a bit. Uh, I think the development is that entire domestic data protection framework do not have to be compatible with the frameworks in other regimes. There can be a narrower compatibility which allows free flow of data. And I think that offers much more opportunity than trying to reconcile all domestic laws, or at least the major domestic laws across countries. So I think that's very interesting, and that is where I think some of the developments will happen. And on that, the last point which I probably want to just mention is the fact that the government of India has withdrawn the bill as it was proposed by the Joint Parliamentary Committee. I would think it's a bit positive in the sense that now, given all of these learnings and experiences that we are seeing, it is possible for us to now come out with a law which actually not only addresses the key objective of ensuring privacy, but also make it much more easy, or at least enabling for it to be compatible with some of at least our major trading partners, which is essentially, if you look at from IT and ITS industry, it's 80% is US and EU. So that's the opportunity for us. I'll pause here, Trisha, but there is a lot to discuss, and happy to come back later.
Thank you, Ashish. I think you raised a very pertinent point in that it is really the uncertainty that is perhaps affecting industry the most, just not having a sense of clear standards across jurisdictions. You're having to abide by one set of standards in one jurisdiction, another elsewhere. So important point there. Just quickly, if anybody has any from the audience has any questions, please feel free to drop them in the chat. We'll address them during the course of the discussion as well. Peter, we'll turn back to you. It seems like your internet is functioning better.
Can you hear me okay now? Is this better?
Yes, much
okay,
better.
I'm sorry, everybody. I'll make very brief comments. One is that the report shows that the UK was able to make an agreement with the US without changing its entire system for criminal procedure. It changed its system only for the international requests, and that's a much simpler, less disruptive approach. And so I think the report shows how that can be a possibility for India. Second, the report talks about issues around free speech, where the laws in the United States are different from England or from India. And so there was a specialized system set up so that certain kinds of crimes would get different scrutiny. So crimes that are the same in India and the US would be considered very easy. If there's a crime that's only on one side, it's a crime for blasphemy in India, but not in the US, then there was an extra layer of scrutiny for the United Kingdom approach. A third point is the US is probably going to start talking more seriously with the European Union about a Cloud Act approach. And the European Union has different kinds of human right protections, for instance, in Hungary and Poland, than it does in some of the other countries. And so we'll see these EU negotiations as a possible way to look about how the human rights issues are handled for this. And then the last piece is for data localization. The report talks about how many of the goals of data localization can be met if there's a copy made in the local countries, such as India, by mirroring, and that's different from hard data localization. And we may come back later to some issues. I've written in the Economic Times of India about cybersecurity risks from data localization. But for now, I think the main point is the report shows a path for negotiating something here that's much more practical than probably a lot of people thought. And so I congratulate the authors on the report and ORF for having the event today. So I'll stop now.
Thank you, Peter. And yes, we'll definitely come back to the interesting point on the relationship between localization and cybersecurity later in the discussion as well. Astha, we'll turn to you next. So some of the trickiest issues arise from the fact that data flows have become somewhat of a battleground between national security, commercial interests, and individual rights. And often it's the latter, individual rights, that get eaten away in the process. Will aligning with the Cloud Act alleviate any of these, or is this a bigger issue, and will this just be a band-aid solution to that?
Yeah, so I mean, thank you for the question and thanks for this interesting discussion. I mean, like you said, that in the context of India, especially, we've been seeing that individual data rights, or even data rights of groups and communities, which we've started to talk about, have not necessarily taken a back seat. It's just that because we've been waiting for this data protection framework for as long as we have, understanding and sort of claiming those rights has been complex for us. And we also often find ourselves in a conversation with the government, whether it's on encryption, where the government is seeking backdoors, or whether it's on data sharing for health or for other sort of quote unquote social purposes. It just becomes, like you said, quite complex, and in that process individual rights are often ignored. And we can see also from the way that the government is positioning itself with regard to both data protection as well as data sharing. It seems like all frameworks at the moment will place the government of India above what is required of other stakeholders. So whether it's in the case of the non-personal data framework, where the government requires mandatory sharing, or the exceptions in the last version of the data protection bill that we also. So in this context, I think that, and we're also seeing, as India it gets ready to take on the G20 presidency, there's a lot of discussion on cross-border data flows there. We already refused to sign on to the cross-border data flows with trust stuff that Japan was proposing, and we seem to be while we're in principle saying like data governance is important and we should be putting our heft behind it, whenever it comes the time to walk the talk, we're sort of always found a little bit short. And I appreciated that the report is able to say that, like the other speakers have pointed out, that their laws of the country don't necessarily need to change too much to be part of the Cloud Act, and that that's possible to do. But I think without a basic data protection framework, that is very, very hard to do. And I think that any kind of, like I said, claims against harm can't be made. And also sharing data for, like I said, and this was a case in Kerala during COVID, where Kerala had a third party to process its health data and give them insights. And there was a case against the Kerala government, and there was an exception that was granted. So for all of these basic things that state governments might want to do, that citizen groups might want to do as well. Things are becoming more and more complicated without a clear framework. So I think my view is that being part of international agreements such as the Cloud Act, whether it's in full or in the way that is suggested in the report, will definitely give us a sense, will make sure that the government understands that there's more at stake, and is able to pull the country up to certain standards. And like Ashish said, that the withdrawal of the data protection bill comes at a good time, where we can learn from some of the conversations that have been happening over the last few years. COVID, of course, has taught us the value of data sharing. The conversation with the Data Governance Act in the EU has taught us some more. So I think that it's a good time to go back to the drawing board and rethink some of this. And yeah.
Yes, thanks, Asta. It would seem that the opinion is generally divided on whether the withdrawal was a good thing or not. There's some who are saying that it's been an urgent requirement, legal requirement for years now, and this is just it's dragging on for too long. But as some of you have mentioned, hopefully going back to the drawing table, we'll have a better version than I did before. Arvind, I'll turn to you next. Now, the draft PDP bill, as I mentioned, was a somewhat imperfect solution to some of the issues that we have discussed at the session today. But largely, the opinion was that it would fill a critical void when it comes to digital economy regulation. So what are your hopes for the new draft? And would you also like to weigh in on some of the comments that Sreenidhi made as well?
So number one, Trisha, thank you. And thank you everybody before me for keep educating me. But let me just start by saying there is not going to be no bill that will come out at any point in time that will be absolutely perfect. Especially when it concerns data or digital, right? So it's a utopian world. We imagine any law to be 100% perfect, because by the time it gets passed, even that 6 months that it passes the parliament, probably there are so many new developments and changes that happen globally that that will make bring some holes about in that law. So having said this, I mean, this the debate on the current PDP bill that has been now withdrawn started way back in 2017. I still remember when I was in the government, the first meeting, one of the first few meetings, this discussions was this round table, and the discussion started, and we were really hoping that this, as an industry now, as an outsider, and as a person who follows this and does the research on this, I believe that it was high time that we should have passed it. But nevertheless, it's been withdrawn. And I think there is a silver lining to that. And the silver lining is that it's, instead of having multiple laws, I mean, maybe one for the PDP and the other with non-personal data, the intent of the government is correct, that can we combine this to a single data bill, which will then also remove that ambiguity, if at all, if it exists. And sometimes if you put on the lawmaker's hat, there's a lot of ambiguity that exists in their minds, and we may be very clear about personal and non-personal data. So I think they have come out with a good thought, that and that is the good part, that you take the hard work that has been done, which includes whether it's NASSCOM as an industry body, all civil society, startups, international platforms, Indian companies, government of India by itself, multi-ministry task force. So a lot of work has gone into it. My thing on the data bill, the new data bill, would be that number one, it should be sorts of data, personal, all open data, everything else, and it should bring about an authority, a data protection authority, which it had proposed in the past also. And lastly, I think India is realizing very clearly that, and I think Asta said this, and I think the importance of citizens when it comes to data is very important. And I think given our approach to digital public goods, and this, and the trust that people have in our systems today, I think it's important to back it up with the right data protection and privacy bill. Having said this, two very important things, that DAPA, the architecture, the technical architecture, digital empowerment and protection architecture that is the government is going to bring along with the with the uh, with the proposed legislation is all ready. So we're hoping for the legislation to come reality pretty soon, and then the enabling technology and architecture is going to be there. Three, we have to recognize that I think we do have a right to ask for certain things the way we also want it. It's no longer just because most of the data is stored maybe elsewhere, or that is the erstwhile leaders, and with, whether it can be anybody, but we do have a discussion at the high table when it comes to discussions. And the last point I do want to make is that I think these are two. We have to think of this as an and world and not or in the sense. And the brief point I want to make there is, once you have the Indian Data Protection Act and the legislation, and we also need to work with the UD under the framework, the Cloud Act framework that they have, where we can do this in real time. Maybe also introduce our frameworks, like many countries are actually implementing DAPA framework as we speak. So can the data sharing and data flows be made into more real time? One of the things, and I think the report talks about it, because of the ambiguity of discussion of certain legal terms, freedom of speech, and the contextual, societal contextual, which is different between India and US also, a lot of requests to get rejected or take infinite amount of time, which really doesn't serve the need. Why we've always seen, at least from the law enforcement side, the Home Ministry side, that requirement for localization of data. So to allay those fears, I think we need to come up with a stronger, faster way of sharing data. So I leave. I hope I was clear. I just heard a comment which said that there was some audio break, but I'm on a Chrome browser, so I hope it was clear.
Thank you, Arvind. Your audio was breaking up a little in the middle, but I think we got most of your points. Could you also briefly just, you mentioned DAPA, but for those in the audience who might not know what it is, could you just briefly outline what the proposal is?
Yeah, so along with the as an architecture, as a technology, we also believe that at a large scale we would need some technology solutions to implement all these regulations that we are going to bring about. Has been experimenting is called the DAPA architecture, technology architecture, which is the data empowerment and protection architecture. And as the name suggests, it has both sides to it. How do you use data for more empowerment, which is the citizen empowerment, the user empowerment, but also provide them the adequate protection in terms of consent, access, encryption, who can share it, and the and whether it's further shareable or not. So that is what DAPA stands for.
Thank you for that. All right. So just a quick reminder, if anybody has any questions, please feel free to post them in chat. In the meanwhile, I'd like to back to Peter. You had mentioned in your initial starting comments about how localization could weaken cybersecurity in the country. Could you elaborate on that?
Yes, thanks for the question. And this is a research project that we're doing generally about how data localization, for instance, in Europe or in other countries, can affect cybersecurity. And so a few weeks ago, I had an op-ed piece in the Economic Times in India about this. That was, and I'll mention a few of the points. I think one of the points is that you have companies. India has a very large sector in IT and IT-enabled services. And the reports that we've seen showed that it's about 40% of India's exports, and a majority of it is for global clients outside of India. So this is a large sector, third-party cybersecurity services and third-party IT services. Now, in order to provide those services, you often have to, the company that's providing the services has to gather IP addresses, gather information about how the company's data flows are happening, do intrusion detection, and then send information back to other places about you can do this, you can't do that, or this is an area of risk, or this is an area that's working. And so the actual day-to-day work of cybersecurity often includes sending detailed data across borders. And if India wants to be providing cybersecurity services, if India's companies want to be receiving and sharing in cybersecurity services, those services depend on flows of data across borders. And so one possibility is if there are, in the future, data localization rules, you could imagine, for instance, having exceptions for cybersecurity services so that the day-to-day operations of all these IT services can go forward. Another part is if you have companies that operate in more than one country, if there's a company that is based in India that operates, for instance, in Europe or the United States, just to run the company, to know what your inventory is, to know what the things are that are happening in your company, you need to be able to see where the threats are happening, where people are escalating privileges, where different problems happen. And so we're doing this research partly because people hadn't looked at the harm to cybersecurity if you put up walls between countries. And that's not saying you can have unlimited data flows everywhere for all purposes, but it's saying at least don't wreck everybody's cybersecurity as you're thinking about having some localization rules. We've written about this, and if you put my name in with data localization, you can find the academic research papers on it. Thanks.
Right. Thank you, Peter. You mentioned an important point, which is that to be able to effectively respond to some of these threat actors who don't usually just operate within the borders of one country, that kind of data sharing is quite necessary. All right. So we briefly, Astha, you had briefly mentioned about India and the G20. As we all know, India is taking on the presidency of the G20 next year. Digital economy and data is likely to be large on the agenda. Do you have a wish list for how India should engage with the G20 in the coming year on data issues at the particular points that you hope would be addressed? Astha, I don't think is here. All right. Sreenidhi, perhaps we could turn to you first and then go down the line. Sreenidhi, are you able to hear us? We can't hear you. Okay. So while we figure out Sreenidhi's audio issue, Astha, perhaps we could turn to you first then.
Sorry, I totally missed the question because I dropped off. I did catch that
yes.
You wanted me to say about G20.
Yes, just a wish list for how you wish India would engage on some of these data issues within the G20 framework.
Yeah, I think India has a big responsibility to take on that leadership and also position itself as a country that cares about data rights and is also willing to engage and deal with some of the big criticisms that we've had on our questions around localization or the sovereignty position that we've taken. And I think those are issues that we need to talk about much more openly, and being in the presidency of the G20 is an opportunity to do that. I think that also what Arvind mentioned, some of the stuff that we built on the digital public infrastructure side and DAPA in particular, I think is something that offers us an interesting opportunity to also put forth alternatives to what is also being discussed in different parts of the world. So I think both from an intellectual position on thinking more critically about and positioning ourselves as a country that champions data rights, but then also offering techno-legal solutions like consent managers that rely on open protocols, that rely on open networks as an alternative to some of what is being suggested is an interesting position for us to take. And we very well can take that leadership position as we go forth.
Thank you, Asta. Sreenidhi, is your audio working?
Yeah, I'm
Okay.
sorry. I think my browser was hung there for a bit. Can you hear me clearly now? And is my screen? Yeah, no, I kind of echo what Asta said about just positioning India. I mean, we are at a position where we're sort of, finalizing the data protection law, looking at different various aspects of data governance and trusted data flows. And I think Arvind had also alluded to the fact that we're sort of deliberating a model would work best for us. I think our own experiences with data and just our ethos on privacy also maybe different. And that's always sort of a starting point for when we're finalizing or when we're working towards our approach to data governance and our approach to sort of negotiations with other regions as well. Several regions, of course, have gone through this learning curve of just what sort of data protection law to build out, whether it be the GDPR or Japan, South Korea, which have different models but are still considered adequate by Europe, whether we look at sort of these Cloud Act or other regimes. And maybe what helps us to glean out this sort of common minimum, the absolute core privacy principles that can help with, say, trusted data sharing, which can also facilitate trade. Perhaps that's sort of a conversation at a bilateral level or multilateral level also that we continue to have. What are those basic themes or basic principles? While the way that different regions might interpret laws or interpret these principles may be different, but perhaps there is that common minimum to glean out, which Ashish had also alluded to in some of these conversations. Just core principles like minimization or purpose limitation, which can help build a framework for trusted data sharing across borders.
Yes, thanks, Sreenidhi. I think a lot of G20 members are also perhaps going through the same debates that India is going through when it comes to some of these data protection frameworks. And there would be an appreciation of the different frameworks of data sovereignty, cyber sovereignty, that's also gaining traction in a lot of countries. So perhaps that we could perhaps find still some common principles within those. Ashish, would you like to chime in as well?
So, I think what I understand of the G20 framework is that there are different formats of conversations. In some, you're trying to come to an agreement. In some, you're just sharing knowledge and point of views and assessing where things might be headed. So, if you look at from a point of view of pure personal data protection kind of a law, I think it would. My guess is it's too premature for us to think of having a discussion at a serious level in G20, hoping that we actually have a final round of consultation on our own bill within this calendar year, which will be a good early step for us to say that we are now firmly on the route to have a data protection law. I think, but from a G20 perspective, I think to contextualize this data conversation somewhere in terms of our work on public digital platforms and the technology stack that we have built, and try to build a use case based interoperability around some of these areas is, I think, more meaningful in some sense. And that's where we have leadership. We have shown success and across various applications. So really, I think that's really the thought process as far as G20 is concerned. And just to kind of comment on what Peter said about the cybersecurity use case, I think there is a lot of this understanding which we are hoping will go into the government's thinking, and also what Arvind mentioned in terms of the fact that the technology is moving so fast that if you are going to have a very prescriptive law, then you are going to probably bind yourself into some kind of inflexibility which is potentially undesirable. So what we are hoping is a law which is a little more at a level of principles and framework, and give space and flexibility for DPA to adopt an approach which is suited based on risk rather than a default which has to be applied across situations. For example, mirroring, it's like a default today. You may want mirroring, but why do you want it to be a default, right? So just an example of that. So I think some of these things are really that we as industry are hoping for, and eventually this will result in more certainty, lesser cost, a more scalable law when you think of the context of India. And I think there is a lot also to learn from industry itself. So just to make the last point, without data protection law, we are processing data of over 120 countries for maybe around 30 years now, and with no major significant blow up. So it reflects both the contractual confidence and the fact that to the extent technology can be used to address concerns of clients and customers. So I think the law should only then further strengthen this rather than make it much more complicated. And I'll leave with that, Trisha. Thanks.
Yes, you make an interesting point on use case based requirements, essentially, so a risk based approach as opposed to like a blanket rights based approach, which is an interesting proposition. Arvind, over to you.
Yeah, so I wanted to, I think everybody, Ashish, including Sreenidhi, Asta, we've all spoken um, on in the G20 framework and the India stack or the Aadhaar stack and how we can take leadership. I think the angle that I want to, and because it has leadership, is how can we build. There are two tracks already dedicated to the digital side. One is more on the inclusion side, financial inclusion and digital inclusion, and the other is the data and digital economy. The third, I think it brings about all these issues which even Peter is mentioning, is a trust in technology. And I think with the amount of checks and balances we go through from being a technology emanating from a very democratic setup, I think DPGs are a great example of that, the digital public goods that India produces. So I think we have to bring that trust in technology as a discussion item, which will help in um, solving some of the big problems. And of course, DPGs are part of that solution, the digital public goods that India has to offer. So, but when you talk about trust, it talks also about data flows. It also talks about, this whole issue of how can you share technology, how can you, what has worked in one country, how can it work in other countries? And I think that would be my suggestion that I would put forth in this forum, that we should think about driving within the, in the one of the parallel streams.
Thanks, Arvind. You also raised an interesting point, which is trust. A lot of our conversations on data protection, data legislation often just boil down to a question of trust, whether it's trust between governments and companies or trust between users and the data fiduciaries. So that's certainly an interesting theme. Now, a final round of just like quick fire comments, because I think we don't have much time left. Turning now to the next few months as the Ministry of Electronics and IT works on the new draft of the data protection legislation. Some of you have already laid out what you hope would come out of this new piece of legislation. But if those of you who haven't yet weighed in would like to come in with your comments, Sreenidhi, for example, what do you hope would come out of this blank slate, so to say?
Sure. Maybe three big themes. One is perhaps keep it limited, focused to personal data protection, which was the core idea to begin with. I think including non-personal data within the remit of the law, also recommendations around including hardware, software security certifications might be adding too much and setting this up for trying to do too many things with this one law. I'd sort of argue that we might be in better stead and closer to seeing a data protection law come to fruition if we do focus on personal data protection with the original objective of ensuring individuals' privacy in mind. That's one. The second would be just focusing on building an effective, robust regulator. I think the law is and privacy laws have to necessarily be principle based, and the real meat of implementation and enforcement will come in through the regulations, codes, everything that this regulator does. So I do believe that it's critical to get that regulator right, be it sort of administrative capacity, ensuring the kind of expertise that that regulator might need, what sort of resources they might need, that and keeping the law sort of principle based. And the third theme would perhaps be just tying it back to our paper as well, maybe extending some of those core privacy principles to government data collection, even for investigative purposes. Maybe, and I know surveillance law is an entirely different ball game, but perhaps themes like security safeguards and just having the requirement to have a retention policy or thoughts around retention, maybe those, not the whole gamut of course, but some of those perhaps it makes sense to include those for even law enforcement investigations or in the law. So those would be my three takeaways.
Thanks, Srinivasan. I do sense some disagreement with what Arvind had laid out, which was that the legislation should actually consolidate some of these very disparate documents like the non-personal data framework that have come out. You also, of course, raised a pertinent point on government collection of data, which we haven't quite gotten to in the course of this discussion, and whether the government even has the capacity to process and interpret so much data. Yeah, so we can turn to Peter next. Would you like to weigh in with some of your thoughts?
Thank you. I think I'm not going to try to comment on what India should do for its own legislation. I'll point out that there are two somewhat different debates that are happening internationally. One of them is the data free flow with trust, especially around government access to data. And there's increasing discussions, for instance, in the OECD and in other forums about what the rules for government access should be, which is something Sreenidhi just mentioned. And Europe is requiring quite strict controls on government access as a condition of access to its own market going forward. A second realm is the commercial data, whether it's for personal data, non-personal data, and there's a great amount of disagreement about how to do that. But I think the rules for commercial data can be negotiated somewhat differently from the rules each government has to think about for its own access to data. And will there be some assurances of limits on that for law enforcement? I think if the Cloud Act comes back as a serious option with India and the United States, it will be the government access to data and having some safeguards there. That will be the focus of the discussion. Thank you.
Thank you, Peter. I just want to raise one audience question and see if anybody has any thoughts. I think we just have like a couple of minutes left, but someone asked, won't it be harsh for the Indian business community and state governments to shoulder the rather heavy burden of control of data flows without the infrastructure and technological expansion potential that US has, which kind of goes back to the point I briefly mentioned about capacity. Would anybody like to weigh in on this point? Astha.
Yeah, hi. I mean, I think that the question on government capacity is a really big one, and we also raised that as we were thinking about the government's role in making, like I said, NPD sharing mandatory, and I think that whether it's on quality, whether it's on processing, storage, etc., the government of India really needs to think through its own capacity and also the frameworks for how we engage with data, whether it's, and you'll see that in a lot of government documentation, there's 3 or 4 big themes. There's the protection stuff, there's the sharing, but then there's also a more problematic monetization question. So I think even in terms of the capacity to regulate, let alone manage data, I think is a big question. And I think that we do need to do much more to create that infrastructure in India to make sure that data sharing happens. The consent manager framework is a start. So, it's being adopted in the financial sector, has been proposed in health as well. But then also other instruments that we've been researching, whether it's through, things like data cooperatives, etc. So how do we also expand that institutional framework, not just to the government, but also to other institutions that can think more critically about data? But absolutely, I think that the question of government capacity is something that we run into all the time, and anybody who has tried to share or try to receive data from the government will realize that government data actually is of extremely abysmal quality and without any resources to bring that up to a certain standard.
Okay, thanks, Asta. We have run out of time, but perhaps you could just do 20 seconds each, one key takeaway, one point you would like to raise. We can start with Arvind, then Ashish, Peter, Sreenidhi, and then Asta.
So thank you. I think my summary would be that I think India and US have a lot of things to work together. India has its own Data Protection Act, the Privacy Bill to be tabled and make it in a whatever the best form it can be at that point in time, but also work with the US on multitude of whether it's data sharing or within the Cloud Act. So I think we can do both. It's an and world. And thirdly, India, I mean, the world and everybody else has to recognize while the US has a lot of data centers, much more data capacity, India is the data capital. We produce the highest amount of data that is there now, and as a free and democratic country. So I think it's a partnership of equals, and it's not something that can only be treated by one country to another.
Thank you. Ashish?
Yeah, I think I'll echo what Arvind just said, just in the context of India US, given the importance at the level of trade of this partnership. I think it would be good if taking off from this report, if the importance and perhaps getting on to a what could be maybe an early discussion to say that in the India-US context, what could be the expectations of such an executive agreement, and building on that conversation, so that while it may some of it may already be positively reflected in the new version of the bill, but then there's a lot more that will happen in terms of the rules, regulation, and so on and so forth. So to the extent we can build the foundation which allows us to have this conversation, not just with the US, but with other countries, I think that's a track that's worth pursuing. Thank you.
I think you said my name next. Thank you
Yes.
for including me. Arvind talked about India as the data capital, and my perception is that India data technology services and information technology is an absolutely enormous and growing industry in the world. And so part of the solutions going forward should be what's going to work well for that important and growing aspect of India's own economy, and setting up rules that work for all the different actors internationally is going to be important to let that part of India continue to grow and be a global leader.
Thank you, Peter. Sreenidhi?
Yeah, no, I think Arvind and Ashish sort of covered it. I think sort of exploring these different channels of conversation between India and US and plugging in some of these thoughts to find avenues perhaps for trusted data sharing in a way that works for both regions, for be it private organizations or when it comes to government data sharing. And I think with the data protection law, I just kind of echoing what we discussed earlier, just provide us sort of a great opportunity to maybe rethink or solidify some of the thought process around these different big themes, be it data sharing, non-personal data governance, sovereignty, and yeah, perhaps just gleaning from these different takeaways and building those into the law.
And the last word is yours, Asta.
I mean, I'm happy to forego that space because everything has been said, but thank you for a great discussion.
Great. Thank you. Thank you, everyone. Thank you to the audience for tuning in, and for taking out some time from your evenings or mornings, wherever you may be, to be a part of this discussion.